table? First table? All good? Teamwork. Thank you.
Yes, of course. Hello, everyone, and I was going to say good morning. It's definitely not morning. Good evening, everyone. My name is Lindsay Horn, for those who don't know me. I am the Associate Director of Social Mission here at Bellarmine Chapel. Before we begin this evening, we're going to start with a prayer. So I just invite everyone to take a deep breath, call to mind the Holy Spirit, and we'll begin in the name of the Father, and of the Son, and of the Holy Spirit. God of love and compassion, may we always recognize your spirit in the refugee family seeking safety from violence, and the migrant worker bringing food to our tables, and the asylum seekers seeking justice for their families, and the unaccompanied child traveling in a dangerous world. Give us hearts that break open whenever our brothers and sisters turn to us. Give us hearts that no longer turn deaf to their voices in times of need. Give us eyes to recognize a moment for grace instead of a threat. Give us voices that fail to remain silent, but which decide instead to advocate prophetically. Give us hands that reach out in welcome, but also in work, for a world of justice until all homelands are safe and secure. Amen. Amen. So first off, I just want to welcome everyone to the Jesuit Parish Family's inaugural event of our Journey of Hope series. Members of both Bellarmine Chapel and St. Xavier Church came together to collaboratively plan on events and prayer services centered around the Catholic Church's teaching on immigration. Through sacred scripture and tradition, God asks us to uphold the dignity of immigrants and refugees. As faithful Catholics, we are called to pray for unity and seek immigration solutions that align with Catholic teaching. When the conditions of a dignified life are absent, the Church teaches that people have a right to migrate to support themselves and their families. The Church also teaches that prosperous nations are obligated to welcome those in search of security and proper livelihood. Tonight's event, Immigration 101, will present a bird's-eye view of immigration policy and history of the United States, presented by immigration attorney Rebecca Baibak. Rebecca is a Bellarmine parishioner and mother of 4. Rebecca began working with immigrants while a student here on Xavier's campus, interning for Catholic Charities' Refugee Resettlement Program. Her internship sparked a passion for working with immigrants that led to work with refugees in Louisville, Cleveland, and Johannesburg. Since graduating UC Law, Rebecca has represented non-citizens in a variety of family, employment, and humanitarian matters. In 2025, Rebecca opened a solo law practice, Baibak Law, specializing in family-based cases and naturalization. Please welcome Rebecca.
Thank you very much for the introduction, Lindsay, and thank you for all coming out tonight and anyone watching on the live stream. I hope that this presentation will be helpful. We have a lot to cover, so let's go ahead and dive in. So here's our agenda for tonight. We're going to begin with a history of immigration law. We'll move into some forms of immigration, end with a discussion on immigration courts and a call to action. My goal is to give you a bird's eye view of the immigration process. It is a very complicated legal system. I don't have time tonight to talk about every single policy change that has happened in the last year. Rather, it's my hope that you can walk away with a basic understanding of how the system works so that you can better understand what you might be reading or hearing in the news. I am happy to take questions, though I ask that you reserve them to the end of the presentation so I make sure I have time to cover everything. So let's talk about immigration law and how it has changed over time. So originally, the US had an open door policy. This is where we get the image of America as the great melting pot. The Alien and Sedition Act of 1798 was the first law that allowed the president to expel certain violent criminal aliens from the United States. But generally, immigration laws at this early stage in our country's history focused on naturalization. Should you be able to naturalize after 5 years? Should it be 7 years? The first immigration restrictions came in 1875 to 1917. We saw the Chinese Exclusion Act of 1882, which authorized the exclusion of Chinese individuals wishing to enter the United States. So at this time, there were a high number of Chinese people coming to the United States, settling largely in the West, really being the driving force to building the railroads out west. And as we saw this influx of Chinese immigrants, we also saw a rise in xenophobia, so hence the act. It was followed by the Scott Act in 1888, which similarly excluded Chinese immigrants wishing to enter the United States. This was challenged in Chao Ching-ping the following year, and Chao Ching-ping is seen as the grandfather of immigration cases. Mr. Chao Ching-ping had lived in the United States for about a decade. He left the United States to go visit his homeland in China, and when he tried to re-enter, he was not let in. He challenged this in court, and the legal question presented to the Supreme Court in this case was that the Constitution did not say if Congress or the executive branch had the power to regulate immigration. So, as a side note, if you haven't recently read the Constitution, I highly encourage you to. It is a shockingly brief document. So in comparison to a modern constitution like the South African Constitution, that's like a novel. It answers lots of very specific legal issues. The American Constitution is like a pamphlet. It was meant to be a blueprint to guide us. It was not meant to answer every question. And on the issue of immigration, it is completely silent. So how did the court rule? The court said that the power of the government to exclude foreigners from a country whenever, in its judgment, the public interest requires such exclusion has been asserted in repeated instances and never denied by the executive or the legislative departments. So the Supreme Court gave broad judicial deference to Congress and the executive branch to regulate and control immigration. It did not have to be interpreted in that way, but that is how it was interpreted. So from 1917 to 1951, we saw laws enacted that were focused on maintaining and preserving the existing ethnic makeup of the United States. They were ethnic quota systems. Our modern era begins in 1952, and our current immigration laws are not so much one law passed at a time, but a body of laws that has been passed and amended and changed over time. In 1952, the Immigration and Nationality Act established the basic structure of our current immigration system, but it still contained those racial quotas. So in 1965, Congress shifted away from a racial quota system to a system based on employment skills and family ties to the United States. It has been reformed and amended. In the 1990s, we saw an enactment of a wave of laws that contain a lot of terms that we might hear today, like an H-1B visa. After 9/11, Congress passed the Homeland Securities Act of 2002, which created the Department of Homeland Security. This is where we also have, inside the Department of Homeland Security, we have U.S. Citizenship and Immigration Services. This is the bureaucracy that administers immigration benefits. We also have ICE, and we have Customs and Border Protection, or CBP, which are meant to be immigration enforcement internally and at the border. So I'd like to pause here for a moment and ask you to consider if you know when your ancestors came to the United States. So my maiden name is Seipel, and my grandfather, Stanley Seipel, took a great interest in our family history, and thanks to my grandpa, I know that the first Seipel to come to the United States was Valentine Seipel. He came around 1840 when he was about 14 years old. And Valentine came to the United States along with a wave of Catholic German immigrants who settled here in the Midwest. Valentine settled in Indiana, but many came here to Cincinnati. Valentine is what we would consider today to be an economic migrant. He came to the United States because he wanted a job. He had what we call the American dream. But Valentine and other Catholic German immigrants at the time, they didn't come because they were desired. In fact, they were a hated minority. The neighborhood here in Cincinnati that we call Over the Rhine was called that as an insult, not a compliment. Rather, Valentine came because there was no system of laws excluding him. If your ancestors came to the United States from a European country before 1972, the same can likely be said for them. They didn't do it the right way. They came because there was nothing stopping them. It was a completely different legal system then than we have today. And I think we sometimes have this image of Ellis Island as being a precursor to Customs and Border Protection, asking for your visa and your passport, but it just really wasn't like that. The papers that you presented at Ellis Island were the ship's manifest, which is just where the captain wrote who was on his boat. And in Ellis Island, only about 2% of people were excluded. Those who were excluded, it was generally because they had a contagious disease or because they were deemed to be unable to work. And I think we need to remember our history because the legal system has completely changed, but some things have not. Xenophobia has not changed, and the American dream have not changed. And today those things are living in conflict, and what we're doing with that conflict is what I want to talk about. So let's talk about an overview of the immigration process. First, I want to define a term that I'm going to use here. A foreign national or alien is someone who has come to who was born abroad at a different country, has come to the United States, and is not yet a citizen. So colloquially, we call these people immigrants, but immigrant is actually a legal term that means someone who is a legal permanent resident or green card holder. So I'm going to use the broader term of foreign national. So here is a bird's eye view of the immigration process. We're going to imagine that someone lives abroad. We'll call her Lucia. And Lucia lives in the Republic of the Congo, and she wants to come to the United States to study. After enrolling at a university in the US, Lucia has to apply for a visa at a US consulate in the Republic of the Congo. So this is a visa. If all goes well at Lucia's interview, she will receive a visa like this in her passport. A visa will give Lucia permission to seek admittance in the United States. It allows her to knock on the door. It does not guarantee that she will be admitted. Lucia must board a plane. She must present her visa to the Customs and Border agent. And if she answers the agent's questions to his satisfaction, she will be admitted in the United States. If she does not answer his questions to his satisfaction, if the agent suspects fraud or other immigration violations, she could be sent back home or in some instances detained. For our case, we're going to say that Lucia was admitted, and as proof of her proper admission, she is issued an I-94. This states the date that she entered the United States, her class of admission, here a student, and the date that her status ends. Lucia is now a non-immigrant. A non-immigrant is a foreign national who is admitted to the United States for a specific temporary period of time. There are many different kinds of non-immigrants, and we'll talk about them in a minute. But this cannot be. The Republic of the Congo is a travel-banned country per the proclamation of June 2025, which means that Lucia cannot be admitted on F1 student status because she will not be issued her student visa to begin with. So we're going to alter our example slightly. We will say that it is 2024 and there is no travel ban, so Lucia is admitted and she is here in the United States. She is an F1 student on a non-immigrant. In some instances, a foreign national can change from one non-immigrant status to another non-immigrant status. So for example, Lucia graduates with a degree in software engineering. She finds a job and her potential employer wants to sponsor her for an H-1B visa. H-1B status is for foreign nationals who work in a specialty occupation, which means that it requires at least a bachelor's degree, if not a master's degree. Congress has capped the number of H-1B visas to 65,000 for the regular cap and an additional 20,000 for the master's cap. Now, this isn't actually that many. So historically, there are about 400,000 employers or individuals who have employers that want to sponsor them to fill those 65 or 85,000. So there is a lottery system to determine who is allowed to apply for an H-1B visa. We are going to imagine that Lucia is one of the lucky ones who is selected in this lottery process. She is therefore eligible to submit her H-1B application with her employer. It is approved, and now she is in H-1B status. But here's another problem with our example. In January of this year, U.S. Citizenship and Immigration Services issued a notice saying that they may not adjudicate any pending application or petition for an immigration benefit for a foreign national from a travel-banned country. So USCIS is not even going to decide her H-1B application. So we need to change our example again, and we're going to say that Lucia is now from the neighboring country of Cameroon. Cameroon is not a travel-banned country, so she can submit her application. But then we have another problem. On September 2025, Trump issued a presidential proclamation requiring employers to pay $100,000 per employee that they wish to sponsor an H-1B status. This proclamation was challenged in federal court, and it was upheld. So the U.S. Chamber of Commerce sued the U.S. Department of Homeland Security, and the court held that the lawfulness of the proclamation and its implementation rest on a straightforward status, giving the president broad authority to regulate entry into the United States for immigrants and non-immigrants alike. And what does that sound like? Sounds like Chow Ching Ping. So we'll alter our example again, but we'll say that Lucia is still from Cameroon. She still has an employer that wants to sponsor her for H-1B status, but her employer had a great year last year, and they really need Lucia's highly specialized skills, so they're going to pay the $100,000 fee. They submit their application, it is approved. Lucia is now on H-1B status, and she is still a non-immigrant. Lucia works for several years for her U.S. employer, and now she wants to become an immigrant. An immigrant is a foreign national who intends to live permanently in the United States. This is a green card holder or legal permanent resident. Not all non-immigrant statuses are allowed to move to this immigrant stage. So some non-immigrant visas are designed to just be temporary, and once they expire, the person is to leave the United States. Luckily for Lucia, H-1B allows her to move to that next stage, immigrant status. So after 6 years in her H-1B status, her employer agrees to sponsor Lucia for her green card. The employer and Lucia must go through a process called PERM, which is a process designed to certify through the Department of Labor that hiring Lucia will not negatively impact the U.S. economy or the U.S. workforce. Once she completes her PERM application process, her and her employer may submit their I-140 application, and in our example, we will say that it was approved. This is a visa bulletin, so it determines when Lucia can now apply for her green card now that she's completed PERM and her I-140 application. The visa bulletin is issued by the Department of State each month. It exists because the legal immigration to the US is controlled by statutory numeric limitations or quotas determined by Congress that are applied to certain categories and to the overall number of immigrant visas issued to each country per year. So there are numeric limitations or quotas on how many green cards we give each year to each country. This is the visa bulletin for February 2026. So further explanation of this is beyond the scope of my presentation, but I want you to know that it exists and it determines when Lucia can apply for her green card. Lucia is either going to be in the third or fourth category on this chart, so she will likely need to wait 3 to 5 years until she can apply for her green card. You can see China, India, Mexico, and the Philippines have their own columns on this chart. This is because they're oversubscribed countries, meaning that there are a lot of people wanting to immigrate to the United States from these countries, and they are backlogged. The all chargeability areas except those listed means every other country, which in our example includes Cameroon. So after several years of waiting and extending her H-1B status, Lucia may apply for her green card. She submits her I-485 green card application, she submits her medical exam, and she is approved. She is now a legal permanent resident. After 5 years of holding a green card, Lucia is finally able to apply for citizenship. She submits her N-400 application, she passes her civics test, she passes her English test, U.S. Citizenship and Immigration Services approves her application. She attends her naturalization ceremony, she swears to uphold the Constitution of the United States, and finally, after about 20 years, she has become a U.S. citizen. So a few takeaways about this process. First, it is a process. It will take many years, and in some cases even decades, to get through this process. Secondly, at each stage of the process, the foreign national is thoroughly vetted. Foreign nationals must submit their fingerprints for multiple criminal background checks. At the green card stage, they take a medical exam to show that they do not have contagious diseases. And at the naturalization stage, they have to prove that they have good moral character and that they speak and understand English. Third, this is an expensive process. Applications and forms have government filing fees, and there are attorney fees. So in Lucia's example, her employer might pay $15,000 or more in government filing fees, plus the new $100,000 fee, and they might pay another $15,000 or more in attorney fees. Finally, no one can just become a citizen. You have to be a legal permanent resident first. This is the reason why immigration advocates talk about the road to citizenship. It is a process. So I want to talk about some employment-based options. We'll talk about this very briefly, but there are many different statuses that we will refer to by letters, and that's the letter that corresponds to the section of the code where that status is described. Commonly, this is referred to as the alphabet soup of immigration law. Each of these different visa categories has its own set of rules and regulations, so what is true for one is not true for another. We've already talked about one of the most well-known employment-based options, which is the H-1B visa, but there are many, many others. So for example, there's an L visa. So imagine an international company that has offices all around the world. So they have an executive in Johannesburg, and they want to move that executive to their office in Pittsburgh. They apply for and receive an L1 visa for this executive to come to the United States. Here's another. Let's imagine a scientist. He is an expert in the field of aerotechnology, and he wishes to come to the United States to pursue his research. He applies for and is granted an O visa as an individual with extraordinary ability or achievement. Let's do one more. A Q visa was designed to allow cultural sharing. It was imagined by Disney to staff Epcot. Disney lobbied Congress, and now we have the Epcot visa. There are many other employment-based options in our alphabet soup. You think about athletes, priests, airline workers, but we're going to move on for the purposes of our presentation. So next we have family-based immigration. Previously, we were talking in the employment context mostly about non-immigrant visas. Now we're going to start talking about immigrant categories. So in the family context, we can skip ahead to this green card stage. Congress allows legal permanent residents and U.S. citizens to petition for their foreign national relatives to become green card holders. But a legal permanent resident and a U.S. citizen can only petition for certain close relatives, spouses, children, not your aunts or uncles. How long it will take a foreign national relative to become a green card holder is again going to depend on the visa bulletin. I'm not going to get into the weeds here, but just for one example, look at F1. This is unmarried sons and daughters of U.S. citizens. So for most countries, immigrant visas are now available for cases filed in November 2016. But in the Mexican category, visas are now available for cases filed in December 2006. So this means if I am a naturalized U.S. citizen, I was born in Mexico, I came to the U.S. and became a citizen, I have a daughter that still lives in Mexico and I want to bring her here, it will take 20 years for an immigrant visa to become available for my daughter. A common family-based case is also when a U.S. citizen or legal permanent resident marries a foreign national. I do a lot of work, this kind of work in my solo practice. Foreign national spouses of U.S. citizens are considered immediate relatives, which means that they are not subject to that visa bulletin. This makes marriage-based cases one of the fastest ways to become a green card holder. Unfortunately, it does also mean there's a lot of fraud in this area. So to deal with the potential of fraud, U.S. Citizenship and Immigration Services interviews couples to make sure that their marriage is authentic or bona fide, to make sure that the couple entered into the marriage because they truly want a life together and not for immigration purposes. The USCIS officer will usually separate the couple and essentially play the newlyweds game. When did you meet? Who was at your wedding? What color is the carpet in your bedroom? USCIS is pretty good at finding the fraud in those cases. In addition to family-based immigration, Congress has created a limited number of humanitarian-based means to come to the United States. I specialized in these cases when I worked at Legal Aid. Some of these humanitarian-based means are non-immigrant visas, mainly the U and the T visa. So a U non-immigrant is a foreign national who is a victim of certain enumerated crimes and helpful to law enforcement here in the United States. It was designed to incentivize foreign nationals to feel comfortable coming forward and working with law enforcement. Congress has only allocated 10,000 U visas annually, and there are approximately 400,000 petitions awaiting adjudication. So the process can take 10, 15 years or more to get U status. Next, we have the T visa. This is for victims of human trafficking, labor, or sex. T visas are not oversubscribed as U visas, mostly because victims of human trafficking do not identify as a victim of human trafficking. They don't realize that's what happened to them. Human trafficking is a very specific legal definition, and to determine if someone fits it is a very fact-intensive inquiry. So we have VAWA. VAWA stands for Violence Against Women Act. So think back to the marriage-based context. In a perfect world, a foreign national marries a U.S. citizen or a legal permanent resident, and that spouse with status will apply for their foreign national spouse to get a green card. If instead the U.S. citizen or legal permanent resident spouse uses their spouse's lack of status as a way to control them and to abuse them, Congress has said that that foreign national spouse may petition on their own. The foreign national has to show, again, that the marriage was bona fide, that it was entered into authentically, and they also have to show that they were a victim of abuse. If the VAWA petition is approved, the foreign national becomes a legal permanent resident. Then there's Special Immigrant Juvenile Status, or SIJ. This is for children who are declared abused, neglected, or abandoned by one or more parents by a U.S. court, state court. After receiving these necessary state court orders, the child can file Form I-360 for SIJS status. And then once it's approved, they're again waiting for their turn on the visa bulletin to apply for their green card. Currently, this is, again, an oversubscribed category. Children are waiting 5 to 8 years to apply for their green card. And then we have refugees and asylum seekers. So this one is a bit more complicated. If we're going to talk about refugees and asylum seekers, we need to talk about Eleanor Roosevelt. After World War II, the world was shocked by the horrors of the Holocaust, and everyone was asking, how can we prevent something like this from ever happening again? The answer seemed to be the United Nations and the concept of a refugee. Eleanor Roosevelt was appointed the U.S. delegate to the United Nations General Assembly, and in that role, she played an instrumental part in drafting the Universal Declaration of Human Rights in 1948, which was expanded in the 1951 Refugee Convention and again under the 1967 Protocol. These three laws today form our definition of a refugee. So a refugee is someone who is outside of his or her country of nationality, who has a well-founded fear of persecution based on race, religion, nationality, political opinion, or membership in a particular social group. And they must be unwilling or unable to return home, either because their persecutor is the government or their government is unwilling or unable to protect them from their persecutor. So, The Sound of Music as a famous example of a refugee family. When Germany takes over Austria, Captain von Trapp is persecuted because of his political opinion. He and his family must flee to Switzerland. When they cross the border into Switzerland, they become refugees. This is the MS St. Louis. It was a boat of over 900 Jews fleeing the Holocaust in Nazi Germany in 1939. When they came to the United States, the government under President Franklin Roosevelt sent them back to Germany, and over a third of them died in the Holocaust. This is why Eleanor said, never again. So how does it work today? A refugee leaves their home country and they go to another country. They're often housed in a refugee camp. The UN High Commissioner of Refugees, or UNHCR, will interview them and determine if they meet the legal definition of a refugee. If they're going to be resettled here in the US Citizenship and Immigration Services will perform its own analysis and vetting and agree that the person meets the legal definition of a refugee. The refugee is brought to the United States under the legal status of refugee, and they are resettled by a non-governmental agency here in Cincinnati, that's Catholic Charities. So historically, the US is one of the most generous resettlement countries. In 2024, we resettled over 100,000 refugee families or individuals. This year, the admission ceiling is set for 7,500. Asylum is different. An asylum seeker comes to the United States on their own, and they ask the government to find that they meet the definition of a refugee and should be granted asylum. A person can seek asylum affirmatively by filing with U.S. Citizenship and Immigration Services, or they can claim it as a defense from removal in immigration court. But here this can get really confusing because immigration court is very backlogged, so an individual might wait years to get their asylum hearing. While they're waiting, they're eligible for work authorization. This is a picture of a work card. But the grant of a work authorization has nothing to do with the merits of their case. It just means they have a case pending. And it can be very confusing, but it's an important distinction because when you talk to a foreign national, the important question isn't, do you have a work card? The important question is, but do you have an asylum status? Because asylum status is what's going to give protection from detention and from deportation. Asylum status is what provides a path to citizenship. A work card does not. But what about economic migrants? Remember my great-great-great-grandpa Valentine. He wants to come to the United States today, but he wants to do it the right way. So what are his options? He's probably not going to qualify for an employment-based visa. He does not have a high-level employment skill. He doesn't have desirable skills. And he does not have close family living in the United States, so he cannot qualify for a family-based petition. As far as I know, Valentine was not the victim of crime in the United States, so a U or T visa would not fit. Valentine came to the United States with his father and was later joined by his mother, so he's not going to be eligible for special immigrant juvenile status either. And as far as I remember the story, Valentine was not persecuted personally in Germany, so he probably would not qualify for asylum. So he is what, again, we today would call an economic migrant. And what are his options? He could apply for an H-2A visa as a temporary agricultural worker, but the problem with this option is that it is temporary. It is for 1 year, extended to the maximum of 3 years, and then the individual has to leave the United States. It is not designed to provide a path to citizenship. Also, only foreign nationals from certain countries can apply for this kind of visa, so it is limited. Valentine could try for an H-2B visa as a temporary non-agricultural worker, but again, this is temporary. It's not a path to citizenship. Also, H-2B workers are limited to 66,000 annually with an additional 64 supplemental visas, though the current administration is only authorizing 35 supplemental visas. So it's temporary. He might not get it because it's capped. It's not the best option. There's also a diversity lottery, but he must be born from a country that has sent less than 50,000 immigrants to the United States in the last 5 years. Foreign nationals submit their applications to enter into a lottery to win a green card. Up to 55,000 immigrant visas are allocated annually for the diversity lottery. But this, again, it's just not the best option for Valentine. In 2025, Germany was an eligible country, but it's a lottery. Last year, 19 million people entered to win. Also, it is not an option today. As of December 2025, the present administration has paused the diversity lottery indefinitely. So there probably is no right way for Valentine to legally come to the United States today. There is just little to no opportunities for poor economic foreign nationals to legally immigrate. There's no line for him to wait in. This is one of, if not the greatest problems of our immigration system today. Because people like Valentine, people with an American dream, are still coming. And what we are doing to them will lead me to the next section of my presentation, which is immigration courts. So here we have the 3 branches of government. There's the legislative branch, the judicial branch, and the executive branch. Now, if I asked you where the immigration court is housed, you would probably say the judicial branch, but that would be incorrect. The immigration court and its appellate division, the BIA, or Board of Immigration Appeals, is housed under Article 2 in the executive branch under the Executive Office of Immigration Review, or EOIR, within the Department of Justice. So this is the organizational chart of the Department of Justice. Down at the bottom with my circle is the EOIR, and if you look way up at the top, you will see the Attorney General, who is appointed by the President. Immigration courts and the BIA directly answer to the Attorney General. The Attorney General has the power to hire and fire immigration judges and BIA members without cause. So consider in a criminal context, we have the defendant who stands here with their defense attorney. On the other side, we have the prosecutor who's representing the state standing on the other side. And then in the middle, we have a neutral judge who stands to decide between the 2 parties. In the immigration context, we have a foreign national who is probably not being represented because they do not have the right to counsel. On the other side, we have the DHS, or Department of Homeland Security attorney, who is arguing for their removal. And then within the same branch of government, we have the immigration judge. Both the DHS attorney and the immigration judge are directly answerable to the Attorney General. This makes immigration courts vulnerable to the political whims of whoever happens to be the Attorney General at that time. By contrast, there are other specialty courts that are housed in the legislative branch. They are called Article I or legislative courts. For example, tax and bankruptcy are legislative courts. They are created by Congress, and they are thus shielded from the political whims of the executive branch. This allows their rulings to be more impartial and to be more consistent over time. This American Life recently published a story called The Hand That Rocks the Gavel, in which they interviewed 15 immigration judges. The immigration judges described how, as of September, the Attorney General had fired over 100 immigration judges. And by February 2025, half of the Board of Immigration Appeal members had been replaced. The official notices that these judges received stated only that they were fired pursuant to Article 2 of the Constitution, meaning pursuant to the executive branch of authority, you are fired. The interviewed judges also discussed a string of EOIR policy memos in which they were essentially told how to rule in some of their cases. In practice, this means that the decision in one's case and one's ability to have a case heard in the first place is highly dependent on who is sitting in the Oval Office. So by way of example, let's talk about gender-based violence claims, asylum claims. So in 2014, the Board of Immigration Appeals issued a landmark case called Matter of ARCG, holding that married women in Guatemala who are unable to leave their relationship are a cognizable particular social group for asylum purposes. So the applicant was a Guatemalan woman who had suffered horrific domestic violence at the hands of her husband for years. She had gone to local law enforcement many times, and they never helped her. They always said that it was a marital affair and they would not intervene. And so think about those 5 enumerated refugee grounds. There's race, religion, nationality, political opinion, and membership in a particular social group. So this case opened up the amorphous particular social group to include married women who were subject to extreme domestic violence in countries that did not protect them from that violence. 4 years later, in 2018, under the first Trump administration, the Attorney General unilaterally overruled Matter of ARCG in a case known as Matter of AB, arguing that domestic violence generally did not qualify as persecution by a government. Under the Biden administration, the acting Attorney General reinstated Matter of ARCG. Now the Attorney General has gone back to Matter of AB. So there's this back and forth in case law. Gender-based violence is the basis for an asylum claim. Then it's not. Then it is, then it's not. And it's all based not on the facts of one's case, but on the political party who happens to be in control at the time that your case is heard. And this is assuming that the foreign national gets their day in court. So the 5th and the 14th Amendment guarantee due process of law to any person in the United States, regardless of their immigration status. Due process is a constitutional guarantee that the government cannot deprive a person of life, liberty, or property arbitrarily, but must follow established, fair legal procedures. However, increasingly, foreign nationals are being denied their due process. This is happening in a variety of ways and is an evolving area of law. So one way this is happening is that foreign nationals are appearing in court only to find out that their properly filed cases have been dismissed. Now, with no relief pending before the court, the foreign national is detained and removed to their home country without a hearing. Another way this happens is through preterm missions. So under this policy, if an asylum application is defective in any way, it is denied. So this is particularly problematic because many people applying for asylum do not speak English. They are not used to filling out court forms, and most of them do not have an attorney helping them fill out these forms. Due process is also being denied through third country removals. So a third country removal is when a foreign national is removed from the United States to a country that is not their home country. In some cases, the decision to deport someone to a third country is made after they have been found ineligible for relief. But in some cases, the government is deporting people to third countries as an alternative of having them have an asylum hearing here in the United States. This is again denying the foreign national their right to a trial. And then we have detention. So ICE has the authority to detain foreign nationals without legal status. This was designed to be the exception, but not the rule. It was supposed to be reserved for foreign nationals with violent criminal backgrounds to be held in legal custody while their case is pending. Today, it is the default, even though 92% of those being detained do not have criminal backgrounds. A foreign national in detention can request to be let out on bond, but bond is increasingly being denied. In the last year, immigration judges have denied bond hearings to any foreign national who entered the United States without inspection, which means they entered without presenting themselves at a border. This means that a foreign national who entered without inspection, their only way to challenge their detention is to file a habeas petition in federal court. A habeas petition allows a detained person, a U.S. citizen defendant in a criminal trial, or a foreign national detainee, to challenge their lawfulness of their confinement in federal court. But we're seeing that even habeas petitions are being thwarted. We're seeing ICE move detainees around the country, which makes it very difficult for them to find an attorney. And when they do, it makes it hard for the attorney to determine in what district they need to file their case. When a case is filed, the federal judge tries to respond with swift orders to bar further transfers, but that is met with varying success. Once in court and no longer being transferred, the Department of Justice is struggling to keep up with court orders and missing deadlines. If the foreign national is ordered released by the federal court, ICE in many cases will continue to hold the foreign national for days and even weeks after the court order. When finally released, it is often done in bad faith. Increasingly, we see foreign nationals released states away from home. They do not have their phones. They are not given their passports or their work cards or any of their important information. And in some cases, they're even released in freezing temperatures without proper clothing. And we're submitting these habeas petitions in the hope that the foreign national will just get their day in court. But we've already seen how case outcomes are increasingly dependent on the political party in power. And here's where I might make my liberal friends pause, because there are some cases, like the Von Trapps, who squarely fit the legal definition of asylum. But there are a lot of people seeking asylum with very, very weak asylum claims. Generalized violence, gang violence in one's community is not the basis for asylum. It just doesn't meet the legal definition. It is not supported by case law. Remember Grandpa Valentine. He was an economic migrant. He came to the United States because he wanted a job. He might have been fleeing some generalized violence in his community, but as far as I know, it was not personal to him. He would not be granted asylum today. Trying to fit a claim of generalized violence, a claim of gang violence into asylum is like trying to fit a square peg into a round hole. It just doesn't work. And this is why for decades, the U.S. Conference of Catholic Bishops has repeatedly called for compassionate and comprehensive immigration reform. And what are some of the things that they're calling for? They call for a path to citizenships for undocumented individuals to earn their legal status the right way. They're asking for reducing backlogs in family-based cases to keep families together. They want reform in employment-based immigration to provide legal pathways for foreigners to come to the United States in a safe and humane manner. They ask for due process protections for detained individuals and policies to address the root causes of immigration like global poverty. So what are we supposed to do with all of this? I have come up with 2 calls to action. So first, I'm calling my congressional representative. The immigration legal system has deep structural problems that only Congress can fix. I admit I was very hesitant to do this for a long time, But here's the thing. When I call Bernie Moreno or when I call Greg Landsman, I do not debate U.S. immigration policies with them. I don't talk to them, and I don't debate. I say, I am a voter in your district. I am a mother. I am a doctor. I am a nurse. I am a teacher. I am calling about this very specific issue, this bill that is pending. I am asking you to take a very specific action. Vote yes, vote no. And then I say thank you for your time. I prepare my script ahead of the call, and I just read it. And it's really like voting on an issue, and that's essentially how it is reported to the representative. At the end of the week, the clerk who took my call is going to tell Greg Landsman that we had 300 calls about this pending bill, and 100 were for and 200 were against. And at the end of the day, he does care because he wants to be reelected. So I still write to my congressional representatives, but I do call because I believe that less people do it and it makes a greater impact. And I want to make the greatest impact I can. If you don't know what to say, you can look up a script. 5 Calls is an app. It will give you a script, and it will even give you the number of your local representatives. If it's too blue or too red for you, then find another script or write your own script. But I really urge you to please have your opinions heard. My second call to action is an encounter, and I think that this one is harder because it feels so mundane. But I challenge you to please get to know an immigrant who is most impacted by these policies. In my life, this looks like volunteering. I do not currently practice in immigration court, but I have been invited to participate in a number of local pro bono asylum clinics. I'm not an expert in asylum law, but I know enough about it to know that as it stands, it is barely breathing. And I admit, when I got an email last week about another asylum clinic, a million excuses popped into my head. I am a mother of 4. I'm trying to run a business. Why should I sink 10 plus hours into a case that's just not even going to be given a fair trial? And the conclusion I've come to is that even if my client, this person, is detained and is deported to a country where she does not feel safe, I pray that she will look back and reflect. I was denied my due process, but the people of the United States showed me love and dignity and respect. And I felt that from the lady at the food pantry and the teacher at my child's school and the guy at the health clinic and 100 other people at 100 other times. And I really believe that this encounter, even if the outcome is the same, it matters because it changes all of us. So where can you volunteer? Thankfully, there are a lot of places. There's Bellarmine's Immigration Team, Catholic Charities, Su Casa, Santa Maria, Ola Immigrant Welcome Center, St. Leo's Food Pantry, Fiesta Food Pantry, many more. There's an Immigrant Dignity Coalition meeting every month in the city where immigrant-facing organizations come together and they talk about what help they need. So please, I ask you to go have that encounter and fill that need. Thank you. So I am happy to take questions now, and I will answer them to the best of my abilities. Go ahead.
Most of the world, except the United States and a few others, call a genocide in Gaza. So what's happening to the refugees, and do they have any chance, Palestinians, to come to the United States?
I am not an expert on that issue. I will say who the United States will resettle is highly dependent on the political climate in the United States. Historically, we take immigrants from countries that we are politically sympathetic to.
Thank you very much for the very interesting presentation. I am an immigrant myself, a legal one, a job one from 35 years ago. So I have three comments or questions. One is, There was a bill in the pipeline, kind of bipartisan, right, under the Biden, that was a more comprehensive immigration reform that was essentially killed by Trump, who didn't want them to pass it before he became a president again. Could you comment on that? Because I kind of don't remember the details. The second one is that there is a large Latino population at St. Clement in St. Bernard, which is kind of not too far away. It's very moving to sit in the pews with people who are actual immigrants and probably, well, non-immigrants, illegal non-immigrants. And they also have masses in Spanish and joint English-Spanish. And then finally, it's a sarcastic question. What was the pathway to citizenship for Melania Trump?
She was an O, extraordinary abilities in modeling. And she brought her parents to the United States through a family-based immigration case, chain immigration.
So what about children that were brought over when they were an infant and they are now 21?
So that was the purpose of the DACA program that Obama tried to create, which was the idea of this child didn't come on their own. They were just brought here. It's not their fault that they didn't have the right papers. DACA is for people who came in a limited time. And so essentially for many people, there is no option. For many people in that situation, if they don't fit the timeline of DACA, maybe if they came after DACA was implemented, for example, they don't necessarily have an option.
Can these children enter service? I'm talking about the military. Does the military accept people that are non-citizens that have been living here for a long time?
I don't know the exact qualifications that the military has. I do know that there are special pathways to naturalization for people who serve in the U.S. military, but I don't know what their qualifications are to get in the military in the first place. There's special protections for U.S. military who want to bring family here, shorter deadlines, things like that.
I want to thank you for your presentation. It was excellent. I'm the son of Irish immigrants. They came here in the 1920s with County Mayo and Leitrim. What I find scary, it just seems like the system is so broken. Just so broken. It's so political, and anytime you try a debate on immigration, it gets very vicious and vitriol, and it's like they can't sit down and say, all right, we got a crisis here. How can we fix it? Democrat, Republican, Independent. Whether it's President Trump or Nancy Pelosi or Chuck Schumer, it's like they can't even sit down and have a discussion about the crisis. They get so political and divisive and nasty.
Yeah.
And that's what disheartens me so much is, why can't you men and women sit down in the House, the Senate, and the White House, sit down and say, all right, we got a crisis. Well, and he's right, we need comprehensive immigration reform because it's so broken. That's what I find disheartening. It's so broken. And, when my grandparents came to America, my grandmother said how lucky we are to come to the United States from Ireland because there was a lot of unemployment in Ireland. And obviously the history of Ireland, the British isn't actually the best, but it just seems so broken. I guess that's what I find so disheartening, compared to maybe when my grandparents came from Ireland, West Coast. I mean, is there some way to fix it, or is it just so the political ones, whoever's in the White House, it just feels so broken, nobody wants to fix it in Washington, D.C.
I think we need comprehensive reform. I think what's helpful for me to think, at least, is I think there's just a lot of misunderstanding in immigration, and when we actually sit down and talk to people, a lot of people actually agree that there should be a right way to do this. It should be more streamlined, it should be safe, it shouldn't take 35 years. So it's difficult because it's such a political issue, which is why it's been very difficult to pass comprehensive reform because it's so politicized. But yes, I agree, it's a very broken system.
My understanding is that a lot of economic reasons for our country to be more supportive of immigration. Do you see that as the business community, one way or another, stepping in any way to we need workers for different areas to be able to help with this, or is everybody just duck and cover?
I think like a lot of other areas, there are people stepping forward and saying, this is why this matters, this is why we need this. For the H-1B, $100,000 filing fee, there was a lot of pushback from places like nonprofits and universities that needed H-1B workers and were just not going to be able to pay this filing fee. There has been pushback from the workforce and employers saying, we want more legal pathways to get these workers that we need. There are some companies that are not stepping forward.
You mentioned This American Life, a program. Do you know the title? Or it just sounded like it would be something interesting to
I
listen
just
to.
Googled it. I think it's a podcast.
Okay.
This American Life, Hand That Rocks the Gavel. If you type it into Google, it'll shoot back
Okay.
right up.
Okay. Thank you for your talk. I learned so much, but I have to admit I'm coming away a little bit pessimistic. I'm in a group in Butler County for Immigrant Justice. We're trying to help the detainees in the Butler County Jail, which is growing by the day. These people get no due process. What I'm hearing from you, they don't have money, they don't have attorneys, they're just going to get deported.
The prospects are not good. I think they need an attorney. They need, there are local organizations, local nonprofits that provide pro bono representation. So donating and supporting those local organizations. But I remember years ago, the Butler County facility, there was a very high profile case that people were protesting about, and they were later asked, how much did these protests impact your decision? And they said, not at all. So I have mixed feelings about protest, personally speaking. I think people need to know that they're not alone, and I think that that's the role of a protest. It's not going to change the immigration court judge's ruling in a case. I think what's the best chance of changing the outcome for that actual individual who is being detained is legal representation.
We know there was a huge number of people crossed the border in the middle part of the Biden administration, and we know there's a humongous backlog at the immigration courts now. What happened there? Did people just walk across, or were they all allowed just to come in and told, yeah, you can apply for asylum, go and stand in a 3-year line?
Yeah, so people were allowed to come in saying, you can come in and claim asylum. You could pessimistically say that that was kind of a political stunt to say, I'm letting in all these asylum seekers. There wasn't change to the legal framework of asylum. There wasn't dramatic, no new visas were created for these individuals. So yeah, there were a lot of people that were let in under the Biden administration. They filed their asylum claims. They're very, very weak asylum claims.
Could that have happened under previous administrations, or did the Biden administration kind of wave that through?
I think they just had different policies about allowing people to come in and wanting people to come and have their day in court. But again, for me, the issue is that they didn't actually change the law. So if I can come in and claim asylum, but if if I have a 10% chance of winning, or if I have a 2% chance of winning, is that really helping me?
Has that admitting a lot of people been part of driving down the rate of success at asylum court?
No, I would say the changes, driving down the rate of success has been largely the oversight of the Attorney General, the firing of immigration judges who maybe had different political opinions, or some of the EOI are memos that the judges talk about in the This American podcast. One even said that those who were too biased towards foreign nationals should consider career alternatives.
Lovely. Thank you. Excuse me.
We'll do 3 more questions.
Can I do the next one? There is some kind of right-wing talking point that says that people come across undocumented and they get all kinds of government benefits. Do you know any truth related to, or fact check this?
Yeah, so most different government benefits, it depends, right? Different government benefits have different qualifications as to who qualifies, but most are not going to be eligible for someone who is without status. So for example, Medicaid is for someone who has lawful status here in the United States. So someone who has come here without papers is not going to qualify for Medicaid, for example.
It's pretty hard to get them, even if you are here.
Yeah, that too.
We'll do Billy, and then we'll do one more.
Thank you. I was wondering if you could describe what the person's status would be after they've made an application but are waiting decision with respect to a visa status.
Just application pending. They don't have status until it's adjudicated.
And so if they were stopped by,
You could say, I have this application pending, but it may or may not be enough to get you to any kind of legal protection. So for example, when I was at Legal Aid, we specialized mostly in humanitarian cases like this SIJS, UT, VAWA, and sometimes we would have clients who also had, who were also in immigration court, and what we would normally do in those cases is we would say, Judge, this child has a SIJS application pending. Here's the status on their case. Please, continue this court date out. Give us, just give us more time to let this be adjudicated. In some cases, the court will give you another date. Increasingly, in an example of a SIJ case, the court will say, yeah, but there's no relief pending in this court. So you need to file something in this court. So what we had to do in those cases is we would have to file an asylum case knowing that this isn't a great asylum case, it's a really good SIJS case, and just wait for that to be adjudicated. Other statuses, so for example, a U visa can be approved while the person's abroad. So I had a client that was deported with a U visa pending because the judge said, well, if they get their U visa, then they will be notified abroad and they can come back.
We'll do one more.
Thank you. Thank you for the presentation. Temporary protected status. DHS, CIS has very detailed step-by-step procedures for employers going through the I-9 verification process. I guess first, is it correct to think about TPS as a form of work authorization? And second, do you have any suggestions for an employer trying to stay aware or stay on top of how many changes to TPS there's been over the past 6 months or a year?
So TPS is temporary protected status. If you have TPS, you can apply for work authorization. It allows you to get it. The idea of temporary protected status is supposed to be, if I am visiting the United States from Haiti, and while I'm here, there is an earthquake in Haiti, and it is rebuilding, my house has been destroyed, I can't go back, so I can get temporary status here in the United States while my country rebuilds. So it can come with work authorization. It's really hard to follow right now because the present administration is stripping away a lot of TPS authorization. And so even though they have a work card that says it expires in 2027, if the government says they don't have status anymore, then they don't have a work card anymore. And then there's also all of these suits where the government says, well, we don't have TPS for Haiti, and then someone files suit and they say, now we do have TPS for Haiti. So I would say the best place to get up-to-date information on that is the U.S. Citizenship and Immigration Services website. They have up-to-date, yes, this country has it, no, it doesn't, it expires on this date, doesn't expire on this date, et cetera.
All right, well, thank you, Rebecca. Let's give her another round of applause. So I'm sure there's still a lot of remaining questions, and that's why our Jesuit parish family is going to do a series on immigration that's just not going to be educational components, but prayer components as well, advocacy. A couple of upcoming things. Our next part of the Journey of Hope series will be March 22nd after the 10:30 Mass at St. Xavier Parish. We're doing a prayer service for migrants and refugees. So just look out in both bulletins for more information. Another act of prayer is the first Tuesdays of the month. The Jesuit parish family will be going to the Blue Ash ICE office to say a simple rosary outside the ICE office. And that's it. It's not a protest, just a sign of prayer and solidarity. And the Archdiocese of Cincinnati is doing the same thing, but on the fourth Mondays of the month. And lastly, if you're curious to learn more about the Catholic Church and its teachings on immigration, there's a handout on the stand in the center of the narthex as you're leaving. Feel free to take that as well. And feel free to email me with any questions about the series. And I just want to thank you, everyone, for coming out. I see. Oh, yes. So if you look over at Linda Wheeler, she's holding up a book called Voices of the Border. We have a book study in March, the last 3 Tuesdays of March, which are testimonies of migrants and refugees from the Keno Border Initiative, if you want to hear some more firsthand accounts of people who have migrated. And that's all. Thank you, everyone, for coming out.